Leading off our discussion tonight, Georgia State Representative Tanya Miller. She is a former Fulton County Assistant District Attorney and a former federal prosecutor. Also with us, Andrew Weissman, former FBI General Counsel and former Chief of the Criminal Division in the Eastern District of New York. He is a professor of practice at NYU Law School and an MSNBC legal analyst. And Tanya Miller, let me begin with you. I want to get to the details of Georgia law about grand juries, where I learned a lot today that surprised me. But what is your reading of what happened in that courtroom today?
Well, Lawrence, I think what we saw is what we often see with prosecutors who want to control the narrative of their investigation. Madam District Attorney Fani Willis is obviously concerned about the details in this report, this lengthy report, we can assume. The special purpose grand jury met for more than 7 months, heard 75 witnesses. We heard Madam DA say today in court. That will give everyone a sneak preview into all of the evidence in the case, all of the testimony in the case before she is prepared to formally indict it. So we heard her when she said she's concerned about future defendants and whether or not there would be pretrial publicity that could prejudice the case, that would allow them to ask for all kinds of things like the venue to be changed, the case to be removed from Fulton County. I'm sure those things are real, but I suspect what she wants to do here, which is not uncommon for prosecutors, is keep the evidence as close to the chest as she possibly can until she absolutely has to release it. But once these future defendants are indicted, we know that statutorily they're entitled to discovery. The cat will be out of the bag, and so the need for secrecy is less. And so that is what I am reading sort of between the lines of the presentation that the state made today.
Because you know her and you know the way she works, I'm really intrigued by that phrase, future defendants. She could have said possible future defendants. She didn't. She appears to be someone who is very careful in her choice of words. She also emphasized, as you just said, the possible impacts that this could have on future defendants and what they might try to use this for in an appeal should there be convictions in this case. And so she very clearly seemed to be standing up there saying, as clearly as she could in this particular session, at this level, there will be future defendants, and I am worried about what they will do in appealing convictions using this decision.
I think you're absolutely right. There are a number of ways, if she was trying to sort of hedge her bets here, if she was unsure about whether or not she was going to present this to a regular grand jury, that she could have said it. But she specifically said that there will be future defendants. And her concern is that these future defendants, these future individuals who are formally charged in this indictment, we don't want to give them any ammunition on appeal. So she's not only forecasting that there will be an indictment. I think that's a fair guess to make, although, you know, none of us know for sure, but that she intends to pursue this vigorously, and she intends to defend this all the way up to and through conviction and appeal, and she wants to keep her case as airtight as possible.
Andrew Weissman, what did you take away from this hearing today?
Well, as you mentioned, Georgia law is quite unusual. You have these two separate grand juries, and there was a lot of complicated legal argument. When I step back, what I was thinking is that this may end up sort of being mooted out. When Fani Willis said they're going to be imminent charges, even if the judge was to rule against her and say that this report is going to be made public, it doesn't appear that he's going to rule quickly. There was a lot of discussion about his giving notice to both sides, and both sides may appeal that and get a stay. So one thing that the DA can do here is basically, you know, act with lightning speed to go forward with the charges, and then as she said repeatedly, she was not taking the position that this report should never be released. And at that point, it could be released and the public would be able to see that. There would be some of the downsides that you and Tanya referred to, but there would be less at that point. And so I think that's something to keep your eye on. And I think the word imminent, I think everyone took notice of that.
Tanya Miller, I was stunned when I heard the judge describe the laws governing secrecy in Georgia grand juries. I mean, I understand that in grand juries elsewhere, a witness to a grand jury can immediately walk out of the courthouse and tell every single thing publicly that they said in the grand jury room. But he was saying today, a prosecutor who's in the grand jury room can go out and discuss what happened in the grand jury room. He was saying that grand jurors apparently in Georgia, have the right to discuss it publicly. They simply cannot discuss their deliberations, that the secrecy only applies to the grand juries themselves and not anyone else who's in the room, and that it only applies to their deliberations. That was a very surprising, narrow definition of grand jury secrecy to me.
Yeah, and the reason why it probably is even more surprising to folks is that in practice in Fulton County and in state grand jury proceedings, secrecy is respected. It is sort of the custom. We don't go out and talk about what happens in the grand jury. You don't see grand jurors going out forecasting or giving a recap of testimony and evidence that they've heard. Most of the proceedings in state court are not transcribed, so there's no record of what happens. And so in practice, we've just sort of become accustomed to this notion that grand jury proceedings are secret. The problem is that, we're faced with this very unique situation. And while these are the laws on the books, these are not statutes that we use often. The court kept talking about 2 prior special presentments that happened in the state that he was sort of looking to for guidance, one in Gwinnett County, one in DeKalb County. But that's it. There's really a dearth of case law on it. And when you read the statute and when you take that in conjunction with the Olson decision, secrecy is defined fairly narrowly. So Judge McBurney was sort of doing what he does, and that is set the framework legally. He doesn't typically come into court with an answer. He hears people out, but he's going to research these issues pretty thoroughly before he takes the bench, especially in a case like this. And I think you saw him flexing that he had looked at the law, he understood what it said, and he kind of had the parties really focus in. Okay, we're not talking about a secrecy issue that is supported by case law. So tell me why I should keep this secret.
Tanya Miller, thank you very much for your Georgia state law expertise. I believe we're going to need more of it going forward, apparently for future defendants in this case. Thank you very much for joining us tonight. Thank you.